First matter on this afternoon's calendar is number 94, People versus Anthony Berry. Counsel?
May it please the Court. Barbara Zolot for Appellant Anthony Berry. I'd like to reserve 2 minutes for rebuttal, please.
You have 2 minutes.
Your Honors, Mr. Berry's conviction for unlawful dealing with a child cannot stand because the people indisputably established only a failure to act, and Mr. Berry had no legal duty toward the children. It's a foundation of criminal law that criminal liability requires an actus reus and a mens rea. While in New York, the actus reus requirement can be satisfied by an omission or a failure to act, it's equally the case that for that omission to count for criminal liability purposes.
Can you draw a line for us and when not, you know, this statute would apply in situations such as this?
Well, the statute actually has 2 components. There's the affirmative act part of it, which is, for example, permitting a child to enter. No legal duty would be required of anyone in that situation because it's an affirmative act similar to most other criminal statutes. The government is saying refrain from doing this, refrain from permitting this child to enter. But then there's this other component of the statute, permitting the child to remain. That allows for liability to be imposed essentially for doing nothing, for failing to act, for passive acquiescence, allowing the children to stay there.
In looking at this situation in your brief, let's assume 2 people are married, but the husband isn't living with the wife, and a situation similar to this would happen, but he happens to be there at that particular day, at that particular time. We'd have no problem convicting him, right?
Well, probably not, depending on the husband's relationship with the children. I mean, if he's still in a position of parental responsibility towards the children, if he's still acting as a parent or in loco parentis, which is...
Yet if they were divorced and she had sole custody, we'd say, well, now he's not, even though...
Well, I'm not sure it turns on their legal status as much as his relationship to the children.
Relationship or status?
I think in loco parentis, for example, is really about the responsibilities that you've assumed with respect to the children so that you're, for all intents and purposes, their parent.
Well,
Counsel, why is there no view of the evidence that the jury credited the police testimony with respect to this man's presence in the apartment? The fact that they went in there, he's in his boxers, he's in the bed with the children, the cable bill is in his name, he gives that address as his address on a prior occasion?
Well, there's no question he was present, but the question here is whether he had enough of a relationship with the children to require him to act.
Was there no view of the evidence? Was there no view of the evidence that the jury could have credited that he had enough of a relationship based on those factors?
There was, given the high standard for in loco parentis, there was absolutely no view of the evidence that he had assumed parental responsibilities with respect to these children.
I don't understand why would it be, you know, there's a crack house. Somebody brings their children there. I permit them to enter. I'm not acting in loco parentis. They're not guilty under the statute?
That's a very good point. That goes to my first point, that this statute's kind of a weird hybrid. That would be an affirmative act. You're permitting the children to enter. What distinguishes this case is that
Why permitting to remain?
Well, it's a tougher question, but I would say that we're talking about a duty created by relationship to the children, but their duties can be created by other circumstances. For example, if the defendant himself or herself creates the peril, that might create a duty. And in your crack house situation, if you're running the crack house...
That's the whole point of permitting to come in and, you know, this, whatever the description of is the activity, that's the peril, right? It's in the statute what the peril is. So you're permitting someone to remain in a place where that activity is going on. And to the Chief Judge's question, why isn't there enough in the record here to say that?
Not even the people dispute that there was no parental-type relationship here.
Neither am I with you, but why do you need it? The statute doesn't say that.
Well, it would actually be totally antithetical to the law in New York and elsewhere for the statute to have to say that, because the normal rule in New York and elsewhere in the United States is that action is not required absent a legal duty.
What's the authority to permit the children to remain? What control does he have over any of their actions?
I'm sorry?
What's the authority for the defendant to permit the children to remain or to enter due to anything?
Right, well,
I'm
that goes
asking.
to, right, there really is no authority of any kind. I mean,
What
he
if
has.
the person owned the house or was the lessee on the lease of the apartment and could say, you have to leave, right? That would be the authority because I control this premises.
Well, there are two different kinds of authority, which we discuss in our brief. There is control over the premises, which Mr. Berry did not have either, but someone could have on premises.
That's debatable, right? I mean, based on the conviction by the jury, that may be debatable about whether he had any control over the premises.
True. That's debatable control over the premises. But since the people's theory here was solely on his failure to act, they chose that theory. Liability was predicated on a failure to act. And under longstanding principles of statutory law and common law, if liability is predicated on a failure to act, then there must be a legal duty to act.
But can a legal duty be based on something less than in loco parentis? I mean, in loco parentis is a very, very high standard. I mean, under certain circumstances, we have found people responsible if they were babysitters or, you know, if they were in a position of being responsible for the children at that particular period of time. Why wouldn't that be enough to create a legal duty?
Well, whether or not that could be, and in fact the law has been very strict, at least in the common law in loco parentis, there wasn't sufficient evidence of that here either. The people presented zero evidence of Mr. Berry's responsibilities towards these children. There was only a dearth of evidence. There was no affirmative evidence here. So no matter how low the standard were, the evidence would be insufficient to meet it. It appears that should sort of end the question.
I guess the point is you're arguing for that the standard has to be in loco parentis. And follow up on Judge Stein's point, let's assume it doesn't have to be in loco parentis. All right. What would the standard be? What do the people have to show then?
Well, they have to show the source of I'm actually not sure where they'd be drawing that duty from. I mean, they would have to show that he had a duty to act towards these children.
Let's say it has to be more than he's in the presence of the children. All right.
I would say that if you liken it to, say, a statute that goes a little broader than in loco parentis, thinking of, for example, 260-10 sub 1, which is a particular kind of statute that actually criminalizes a failure to act, or a reporting statute or something like that, well, then you could say there I think it's a caregiver or guardian, but someone who has assumed responsibility for the children in some way short of a parental responsibility. That's utterly lacking here. So I would say 260-10 sub 1 is maybe your best guidance for broadening it beyond in loco parentis, but still not just happen to be present.
Thank you, Ms. Sullivan.
Thank you.
Speak.
Thank you, Your Honor. Excuse me. Your Honors, the people would respectfully submit that, viewing all the evidence and the inferences which may be drawn in the light most favorable to the people, the appellate division correctly held that the evidence established that the defendant knowingly permitted 3 underage children to remain in an apartment.
What if the next-door neighbors knew that there were drugs in the apartment and saw the children go into the apartment? Would the next-door neighbors have a duty to keep them from going into that apartment?
I don't believe so, Your Honor. I don't think
How's that different from what if the next-door neighbors just stopped over for a few minutes?
I understand, Your Honor, yes. I don't believe that that sort of a situation is what this statute was meant to apply to, that the next-door neighbor who suspects or maybe really knows that there might be drug dealing going on next door and that there's children who live there. And the reason why is because I believe that the statute envisions that the defendant who's charged and convicted in this type of a situation is someone who has a certain, at least some type of connection to control over the situation at hand.
Let's follow up on that then. Let's say the co-defendant in the case, let's say that person had intimate relations with someone else other than this man, this particular defendant. Would every person that she had intimate relationship with be eligible to be charged under this statute?
No, not necessarily. I
They
think
came
what-
to the apartment, they were there more than once, they had intimate relations, knew that the person was a drug dealer, knew that there were 3 children there. Under this theory, it would seem that that would be the case.
I think what it would be is that would be a situation of if there's a person who had some sort of connection to, control over the situation like this defendant
So,
did.
all right, so let's go to the control then. Where is the control?
I think the control would be sort of, for example, if we look at the facts before this Court, and again, this is the situation before it. We had a defendant who clearly had a very strong connection to both T.H., the apartment, and her children. By her own account, he slept over at her place at least once or twice a week in the 2 months
What do
before
you
he
think
was
he should
arrested.
have done?
I'm sorry?
What should he have done?
He should have made sure that there was a situation where these children were not exposed to this
What
drug
should
activity.
he have done? In
He
other
could have
words,
he could have gotten the children out of the
Oh,
apartment.
so is there any thought in your mind that if he took these 3 kids out of that apartment, he could be charged with custodial interference, possibly kidnapping, any number of charges
Well,
because they, I'm sorry.
He could have at least tried, maybe called 911, ACS, or even better, this is what he could have done. He could have gotten the drugs out of the
Of
apartment.
course, but you're not charging with the drugs, you're charging him with the kids. And my thought is, as you're thinking, so, well, maybe he could have called 911. That's not a very tight rule to say you're going to be charged with a crime if you don't do this.
No, but that's what I mean. It's not necessarily even necessarily having to call 911.
I don't mean defense, but let me just interrupt you for a minute. You said take the kids. I think that could subject him to worse charges than a misdemeanor. And do you really think that's the answer, that he ought to say to a mother, I'm taking your children because you're dealing in drugs?
Well, he could have at least then had to make sure that the drugs were not in the apartment. He could have separated the children. The idea that the objective
Well,
of this statute.
Why couldn't the neighbor with whom they're friendly and who stops by for tea and who knows the drugs are there, why are they any different then? They come a couple of times a week, every Tuesday and Thursday. They come and they have tea and they know the mother and they know the children. And why is that any more of a connection?
The
and
next-door
control?
neighbor is different, because that next-door neighbor who just comes by once or just suspects that there's drug activity next door doesn't have a...
That's not my scenario here. My scenario is they're friends, they live next door. Every Tuesday and Thursday, they come over twice a week. They have tea. They know. They don't just suspect. They know because the mother's told them she's dealing drugs because that's the only way she can make any money to feed her kids.
That's definitely a closer case. I mean, that person might very well, I think that person would be a harder case for the people, certainly, to bring that case and make it.
What makes it different?
Because that person doesn't have as much of a connection to the situation at hand, namely that the children are being exposed to drug activity.
How is that different than this defendant who says that he shows up a couple of times a week to crash and then leaves in the morning?
Because the evidence established, and viewing that evidence in the light most favorable to the people, showed that there were, well, certainly there was drugs in the kitchen exposed on the plate in the kitchen on the exposed shelf. There was drugs found in a pair of men's pants that were lying 5 feet away from where he was sleeping in his boxer shorts. He had kept clothes in the
Well, he
bedroom.
wasn't convicted of any drug-related crimes.
He was not, but that doesn't mean
Not
that he
even
didn't.
constructive possession,
No.
right?
I mean, we would submit, as the appellate division found, really all that really means is that perhaps that the jury found that there wasn't proof beyond a reasonable doubt that he possessed those drugs. He was in constructive possession of drugs.
Is
That doesn't mean-
possession the activity under this statute, by the
No,
way?
it's knowing or having reason to know that there is drug activity taking
Well,
place.
what's the activity?
Here, well, T.H. Admitted, I mean,
Selling from the premises? Is that the activity?
It doesn't have to be even selling. It's that there's drug activity as defined by penal law, Section
Okay, but what-
220
okay,
of the
so what
penal
is
law.
that?
So in this case, it was possession of a lot of drugs in
So
this
it's mere
apartment.
possession?
Possession with intent to sell. T.H. did,
So you do have a sales component in this.
there was in this case, there certainly, yes, there was.
But I'm asking you under the rule, do you need a sales
No,
component?
you don't necessarily need a sale. No, you don't.
So mere possession?
Possession can be enough, yes. And here he had.
So what's the standard? What's the rule? How do we measure this? Defense counsel's arguing for in local parentis. I'm having a difficult time seeing how we would possibly measure this in this circumstance.
Yeah, well, we would submit, definitely it's not in loco parentis. I mean, there's nothing in the statute itself.
Well, let's say we
in its
agree with
history.
you. So, let's say we agree with you. What is this? What is the rule? What is the standard upon which you would have us determine and distinguish between people who are permitting and people who are not? Because permission implies that you have the authority to permit. So
I would
What's
submit
our
that-
standard?
I would submit that there's an inference here that there is a certain level of control over the situation, over the situation at hand, for the defendant has some sort of control over the situation in order to be found guilty of this crime.
Does that mean not any responsibility or, not responsibility, authority over the conduct of the children?
No.
She's talking about relationship to the children. You are talking about the
Right.
circumstances, which
There's-
sounds to me like you're talking about control over the premises.
No, it doesn't even necessarily mean control over the premises itself. Control of the situation. Here, there was a lot of drugs in this apartment,
I
and
know
he
you keep
has a
talking
very
about the drugs.
active
I'm not
role.
asking about the drugs. I'm talking about how are you going to have the kind of control you're talking about when you have no authority vis-a-vis these children?
I would submit that he does, and that he could have at least tried to get them out of the apartment. If he doesn't physically take them out of the apartment,
Okay,
he
so the
certainly could
mother's
have-
there with all the drugs, and he says, I'm taking the kids. You think he could do that under the statute when the mother says, these are my children, you're leaving before they go?
Well, he could try, or he could take the drugs out of the apartment, tell her, these drugs can't be in the apartment. He has to at least make some effort. On this evidence here, nothing.
You think
Nothing to that effect.
this is what this statute means, that you have to pick up this controlled substance, physically remove it from the premises?
It depends on what the circumstances are. In this situation, he certainly could have tried, he could have told her, you can't have these drugs in the apartment, and the both of them living there.
What if he had done that and then the police raided right after that, and he's charged, so he takes the stand and says, I try to get the mother, but does that save him?
It might. I mean, before jurors, they may feel that in
the
that
mites
situation.
are what troubles me. If we had a
I don't
law
have
that's-
that here. I'm sorry.
If we had a law that says you can't speed down Eagle Street, and somebody's going 17 miles an hour, we said, hey, you're speeding. He said, well, how do you decide speeding? Well, it kind of depends on the situation, and you were going 17 miles an hour when there were people gathered outside, so that's speeding. Somebody else goes down and it's 60 miles an hour. Is that speeding? Well, it depends on the situation. If it's 4 in the morning, no. And we don't like laws like that. We want laws that you could follow, that tell you what's right and what's wrong.
I would submit that this law is perfectly valid. And also, by the way, I mean, there's not that the defendant has not made any challenge to the constitutionality
No,
of the
I'm just-
statute. So
you- see-
I would submit that what it means.
Go ahead, why don't you finish?
Oh, sure. Did I interrupt you? I'm so sorry.
That's okay. Go ahead.
The wording of the statute is when a person knowingly permits a child under 18 to enter or remain in a premises where he knows or has reason to know that unlawful drug activity in this case is taking place, that he can be held liable. Your Honor, Judge Garcia, you mentioned, for example, a situation, if we were to adopt
Just
the
to get
defendant.
back to that situation for a second, is the people's theory in this case, and I think there was some suggestion by counsel, is the people's theory that it was an affirmative act by the defendant, or however it was phrased? I mean, because it seems to me, could the rule be you have to have some authority over the premises or the children? And would the rule like that, would the theory of the people's case here be consistent with a rule like that?
Under the facts of our case, yes. He has certainly had enough. The evidence here showed that he definitely had a strong connection to this apartment. He stayed there fairly regularly.
What about the dog walker? I give the keys to the dog walker.
Dog walker?
Dog walker comes in and get the dog. See the drugs all over the place. The 14-year-old is playing on the TV.
That
What
might
does that
be-
dog walker have to do?
You
Have
know,
to take
again-
the drugs instead of the dog?
Well,
Have
that
to
might be a
call
closer.
911?
That might be a closer situation. Again,
Oh,
I would
know,
submit.
but this is the point. Where are we drawing those rules?
But,
Where
Your
do
Honor,
you draw the line?
those are not the facts before this Court. And I would submit that we do. It's very important that this Court look at the circumstance, look at the evidence that was produced in this particular case.
Yeah, but we're
There
trying
may
to
be closer
interpret the
issues in other
statute.
cases.
Aren't we also trying to interpret the statute, not
Yes.
just for this case, but for future
Absolutely.
cases? Because we're trying to give people some kind of guidance about their conduct.
Absolutely. But the kind of rule, the kind of requirements that the defendant is urging here, namely that you can't be convicted of this crime unless you're a parent or a guardian of the child at issue, that can't be, because that would mean that the drug dealer who, sells in someone else's home where that person has children there, he can't be convicted because, or he sells out of a daycare center.
He did something.
He can't be convicted because
But he did something affirmatively. He brought the drugs into that home.
But I don't see,
Where
there's
there
not,
were children.
under the law, there's not a distinction between whether the person himself is the one dealing the drugs or not. But what if the person is the one who's bagging the drugs or somehow is like a little lesser role, but is involved in a drug selling operation that is not conducted in the person's home. It's at a daycare center. There's children there. None of those children are his children. He's not the parents to any of these
So
children.
again, I let in the dog walker has the keys, sees my children actually taking drugs.
If there was
Forget the
evidence...
person was bagging up the drugs and just the kids are on the side or in the bedroom and don't even observe that.
If that person was there often enough, if there
Like
was
if he
some proof...
slept there, if your dog walker slept there twice a week.
If there was some, I think that in a circumstance like that, it would be, there may be very well a situation where a jury would find that if that person had enough of a connection to that household and the children and
My
that
example, they have a
situation,
key and
that
they
they
can
could
walk
be
in and
liable.
out. But in my example, they have a key and they can walk in and out.
With the dog walker?
Sure.
Right. That person might very well, under the
By the
circumstances
way,
of
the
the case.
defendant here have a key? I've just,
There was, yes, there was proof that there was a key as well, along with the drugs in those men's pants that were lying 5 feet, 5 feet away from where he was sleeping in his boxer shorts. So yes, there was it. And his name was on the cable bill. So again, he had a very close connection to this apartment and these children. So I would submit, under the evidence in this case, viewed in the light most favorable to the people, there was ample evidence to convict him of this particular crime. Thank you.
Thank you, counsel.
Thank you.
Philip?
On this key matter, there was no proof that the key actually opened the door because the police knocked the door down and impaired the lock. My adversary's...
His name is on the cable bill?
His name was on the cable bill.
In some sense of connection and of a more permanent status to this particular premises?
That was the only evidence of his connection to anything in terms of the operations of the apartment. I
What
understand
about
this is a
evidence
sufficiency
of his
case.
connection to the children? Was there testimony that he was sleeping in the bed with the children?
There was testimony that he was sleeping and the children were in the bed as well with their mother. However, again, in terms of, and I want to be really clear here that a number of the things my adversary has said about how limiting it to parents would be inconsistent with the statute, we're talking about a failure to act case. That's what we're talking about. That's where the limitations kick in.
I don't understand why that's so exciting. I wouldn't, it seems to me, Judge Rivera's example of a dog walker, anyone who sees children in danger, and we're saying, you know, if you permit that to continue, you may be charged under the statute. What's the downside of that?
Well, the downside is that New York, it would really be pretty unprecedented to impose duties on people to act that have never been imposed before. When there's a statute that has a reporting requirement, for example, the legislature is so careful to be very specific about who that reporting requirement refers to. For example, the mandatory reporting requirements about child abuse. You know, there's a list, but it's super specific as to who has that reporting requirement. 26010 sub 1, which is the closest analogy, a reckless endangerment statute based on failure to act. The legislature was very clear about who it referred to, and it refers to parents and caregivers and guardians who fail to act to prevent a child
But
from
if you're
becoming...
dealing with a child, if you have a child in your car and you're smoking marijuana and there's marijuana in the car and that can harm the kid, whether it's your son, daughter, neighbor's kid or whatever, why is that not
Well-
unlawful dealing with a child?
Well, that would probably be reckless endangerment,
Well,
pure and simple.
let's pick on this statute.
But for unlawful dealing with a child, that would be an affirmative act. You're smoking marijuana. You're committing the illicit activity that's putting the child in danger affirmatively. But whether your friend sitting next to you in the car while you're smoking now has to interfere with your children
But if
is
he's
the
smoking
question.
it, then you're free? I don't think we're making that kind of distinction. The focus, it seems to me, is on the child, and you have an obligation to the child.
Well, protecting children is of course a laudable goal, but it shouldn't expand criminal liability to the extent that every conceivable factual circumstance is now, you know, subjecting someone to criminal liability despite limitations in the statutory law, limitations in the common law, requirements that this Court has itself imposed in cases such as Stein and Wong. That's beyond what we should be doing to protect children.
Your light is off. Just a quick question.
I'm sorry.
Do you disagree that activity in this statute can include just the fact that the drugs are on the establishment?
I disagree with that.
Well,
I
then
think
what
that
would it include?
It would, I believe there would have to be a commercial-type component, and I think this Court in Diaz, while not directly addressing that question, implied as much. That was a case where there was paraphernalia and the like.
Thank you,
Thank
counsel.
you.